Good morning, everybody, and welcome aboard. I want to thank all of you for joining here. I see a lot of old friends joining in today. I know you're here to get a lot of questions answered, so we're going to try to do that. We're going to jump right into it. I'm going to kind of take the first part here and do my presentation that I've been taking around the state for the last couple of months. And I know that we've got a bunch of instructors in here that are kind of watching to see what's going on. For you instructors, if you want to get a copy of any of these slides or you want a copy of the presentation, I'm more than happy to share it with you so that you can help your folks in your area understand all of these things that are going on. There's a lot of builds in the PowerPoints and everything. So also for any of you rainmakers that are out there, you've got members on your team, your superstar rock stars like Donald O'Meara, and you want to have us come to talk to your group, we'd be more than happy to do that. Feel free to contact us. Happy to do so. It's good to see Heather Alford on here. I see friends from every different company in the Travis muted me. See, Travis,
you know what? I'm not used to this little co-host role here, and I hit the wrong button. You know what it is? I can't stand to hear anybody else talk other than me. I'm sorry.
There you go. There you go. Well, as all instructors are. So Travis and I are going to kind of play off of each other. Shut up, Peter Keim. I see you. Mute him again. Go to your corner, you pumpkin spice latte loving, pain in the neck Dunkin' Donuts guy. So anyway, so we're going to go ahead and get started. I want to begin with just an overview of the settlement, and then we're going to get into some minutia today. We're going to talk about Form 201, which is the exclusive right to represent the buyer. We're going to talk about Form 203, which is the non-exclusive buyer's agency agreement. We're going to talk about that in detail. We're going to talk about how to use Form 220, how to fill it out, what to put in it, etc. But the most important thing that I'm going to give you is a website. So I want you to write this down right off the bat. Facts.realtor. Facts.realtor. Now, let me tell you a little bit about this site. This is the site that NAR created months ago when they knew that we were going to have lots of questions, and this is where all of your answers are. So if there's a question that you have that we don't know the answer to off the top of our heads, because by the way, there's about 350 links on this site now, so it will take you a long time to get through all of it. But if you have a question, you can go there and go to facts.realtor.com, put it in the search box, and it'll bring up all of the data that they have on that question. So make sure that you have that. By the way, keep your notebook or your notes close by. There's going to be a lot of things that you're going to want to jot down. Again, I'll be happy to share all of this data. One of the things that we are doing today, folks, is we are recording this. And so the goal, we're far enough down the road that we've got the answers to 95% of the questions. And so we are going to post this on the YouTube channels to make sure that people have access to it so that they can see what's going on. So please keep that in mind as we talk. We tend to get a little bit relaxed when Travis and I talk. So if we slip up and use a cuss word here and there, calling something BS or something like that, hope you won't. I see you laughing at us, Tony. You know that it's coming. It's just a matter of when, not if. So I see that laugh coming out. So let's start with the overview and begin there. So first things first, this settlement all has to do with a lawsuit that was brought by sellers only. Folks, I'm probably going to scare you when I say this, but there's likely a class action buyer side lawsuit getting ready to come too. It's going to be down the road with the seller class action in Missouri that we're talking about. By the way, it was in the state of Missouri. What they basically said is that they were required to pay the buyer's agent to compete against them. And that was the way that it was being presented. So let me give you an example. And we've said for years, by the way, the initial lawsuit on this was filed in 2016. It got class action status back in 2017. Anybody remember the listing agreement Form 101 changing in 2017 to where it finally broke out? Here's the total compensation, and here's what the buyer agent or the sub agent is being paid. That's when we did that. That's why it happened then. And so that's the reason that was put in there. The problem is there were a lot of trainers, like myself included, that used to tell you, hey, go ahead and put that 6% or that 5.5% in there pre-printed, and put in the pre-printed 2.5%, 2.4%, 3%, whatever crazy number you want to pay. Just go ahead and automatically put that in there so it implies that it's not negotiable. Well, folks, that's exactly the reason they're getting on us right now, and that's exactly the reason we're in the position we are. One thing that I am not going to get into today, and I know that some of you may have come to this meeting with the hopes of being able to fuss and complain about the fact that NAR settled this, even though we should have kept battling it. Folks, it's past. Get over it. Move forward. The settlement is here. Whether you like it or not, whether you agree with it or not, no longer matters. The fact is, for you to operate your business, you're going to have to make some changes. So we're not going to listen to anybody complaining about that. The next thing we're not going to do is we're not going to take your wild ass creations that have happened when you've taken whatever hallucinogenic it may be, whether you're drinking bourbon like me or whether you're smoking something on the side or whatever, and you've got this weird scenario. We are not here for the 1 in a million scenario. We are here to talk about what's probably going to be about 97% of transactions today. At the end, when we get my questions, and when we get to the questions, if you have a scenario like that and it's too outside of the box, we'll probably say, let me look into it and I'll answer that for you offline one-on-one. So please don't be offended if we say that. So bottom line is the whole lawsuit came about because NAR was accused of collusion to drive up prices. Folks, it was basically an antitrust lawsuit. They thought that all of us realtors were getting together. I don't know if anybody remembers, but back in about 1998, 60 Minutes did a piece. Anybody remember 60 Minutes? Raise your hand if you're old enough to remember that, if you're able. But 60 Minutes did a piece on that, where they talked about the sacred 6% commission. If you want to check it out, it's available on YouTube, the sacred 6% commission. And it had this guy from this really new startup company called Redfin. And Glenn Kaufman was on there. He's talking about all of the possibilities with Redfin coming in and changing the market and changing the dynamic. Then we had a company called Concept 2000 come in. And then there was Concept 2400 and there was Concept 3000, and everybody tried to create different atmospheres, but the basic way of us getting paid stuck. And it still sticks to this day, just for the record. Some of you may not have to change your operations. We're going to show you how to make sure that you're participating legally, though, rather than me still teaching you, hey, walk in there with a pre-printed form. And we're going to talk about that in detail. Again, as I told you earlier, for all of your updates, you can visit facts.realtor, and we can find out everything that you could possibly want to know in that scenario. So let's get to the changes. First things first, ladies and gentlemen, I want everybody hold up your drink. In the words of Bill Gallagher, take a sip. Y'all take a sip of something, okay? Take a sip of something. I feel like Adam Sandler. It's cool. It's clear. It's high quality H2O. All right. Sorry, there's that Gen X reference for those of you. First things first, folks, don't panic. Don't panic. Because we've been through major changes like this for years, you guys, and I'm going to show you what I mean. Let's go back to my era when I first got licensed, folks, the 1990s. Yes, I don't need for some of you to tell me I wasn't even born then, Brian. I don't need to hear that from you today, okay? Do you hear me, Heather Alford? I'm talking to you. There's a couple of others in here. You know who you are. I don't need you talking to me. No, I did not sell the Flintstones their first house, Kaima. Please stop saying that. You're giving me a bad rep, okay? So in 1990s, we had electronic MLS systems that came about, folks. Before this, we had the books. We had the MLS books. They were printed by dot matrix printers. They had a front photograph. No, they were not in color. They were black and white, smart Alec. They were black and white photos printed by dot matrix printers. They had 4 lines. It basically gave you price, bedrooms, baths, and square footage. And then you got 1 line to write in whatever remarks that you had. You timed your listings by when the book was being printed, okay? So we had to really be organized back in the day. So that if we missed the book, it would be another 2 weeks before anybody had access to it. Well, in the mid 1990s, and anybody been in the business long enough that you remember 1994, when the MLS in the Triangle and the Canopy Association of Realtors released a program called Maestro. That was the very first MLS system in North Carolina. And we all had to learn how to run it. At the same time, this website in 1995 came out, owned by the National Association of Realtors. It was called Realtor.com. But in their infinite wisdom in 1998, the board of directors of the National Association of Realtors decided that the internet was a fad and that we should sell Realtor.com. And we did so. I think it was like $18 million that we sold it for. By the way, that website now valued somewhere in the neighborhood of about $1.6 billion. So that was a big mistake that we made. We could have used all of that information for our own benefit. In the 2000s, folks, we had mobile access to MLS. Anybody remember when you had your first beeper, buzzer, blaster, you had the pager? We all looked like drug dealers getting pages. And we would go to these things. Victoria Lopez, we went to these things called payphones. Now, we didn't do it to change into our Superman outfits. We did it to call the other listing agent and say, hey, I want to make an appointment. Some of us had to drive to the listing agent's office in order to get the key because there was no lockbox. Okay, this is the way it used to be, folks. This is the way. Don't laugh at me like that, Victoria. I see she's sitting here going, God, this guy is old. Okay, Dana, I see you grinning and drinking your coffee. You keep going, girl. So the next thing that happened, folks, many of you were around for this, by the way, was 2007, the Great Reset. The Great Reset. Interest rates, home values, all affected by this. The Dodd-Frank Act. Anybody remember the Dodd-Frank Act? That came about. It changed the way we did lending. Yeah, Mark Smith, I know. Mark raises his hand with like a shake of the head. Yes, the Dodd-Frank Act. Oh my God. But the Dodd-Frank Act triggered the next major change in 2015, which was called TRID. Now, only in the real estate business would we take existing acronyms and make another acronym out of it. For those of you that aren't familiar, TRID is the Truth in Lending Real Estate Settlement Procedures Act Integrated Disclosure. Okay? Yeah, all that. For realtors, it simply stood for the reason I drink. Okay? Because all of these changes, they got rid of the old HUD statement. We got rid of the good faith estimate. Now we've got loan estimates and all of this stuff. All of this was happening, folks, under our nose. It took us a couple of years to adjust to that, but we did it. Then, ladies and gentlemen, dun, 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 fast forward, March 13th, 2020, when the governor of North Carolina shut down the state and initially said, hey, by the way, you as realtors are no longer essential personnel. When that edict came down, the North Carolina Association of Realtors did a great job of telling the governor, hey, you don't understand, real estate drives this economy. We need to get that going. All of a sudden, 12 hours, governor comes out with an update, says we changed our mind on realtors. You guys are good. But we learned to adapt. You'd never heard of Zoom meetings like we're doing right now until 2020. You got a delay in your continuing education to the chagrin of all of us real estate instructors that said, wait a minute, we can't throw off 1 year. They can't even figure out when the end of the fiscal year is as it normally is. And now we're going to change it to August. So we had that change come about. Then in 2022, March of 22, folks, interest rates averaged 3.1% across the state of North Carolina. 90 days later, in June of 2022, interest rates averaged 7.2%. So we had a more than doubling of the interest rate. What I'm trying to point out to you here, folks, is the NAR settlement rules and all of these new rules we're dealing with are just the next iteration of what we're going to have to adapt to. So please stop panicking. You're going to learn how to do this, and we're going to try to make it as simple as possible for you here today as we continue through the class. Now, the first thing that you have to understand in terms of what we can expect from our industry, one of the greatest things about our industry is innovation. You see, think about it. 10 to 15 years ago, EXP, Real Broker, companies like that that were all online and virtual in theory didn't even exist. And look where we are today. Those are some significant companies in our area. You still have the traditional companies that's surviving. You have different setups in the way companies operate. You have the Coldwell Banker Howard Perry and Walston that has one license for every office in the state versus a Keller Williams setup where every individual office is independently owned and operated, so they all have different firm licenses. That's going to be important to know depending on how your company is made up as to how your business is going to operate. But all of these companies are coming up with ways of handling this. Many of you have heard that EXP has said, we're not going to publish any buyer's agent compensation. You're going to have to negotiate that with the seller when you present your offer. We're going to talk about that today. I've had some EXP friends that were very good sports and said, hey, well, let me share this with you so at least the information is accurate. It's just one way of covering it. You have some companies that have said, we're going to put a blanket statement on our website that says we pay 2.5% to every buyer's agent. Well, that's great, but if you have one seller that doesn't do that, now you have a potential legal issue. So again, it's the consistency that's going to matter, you guys. What I will tell you that we can expect is we can expect it to not be perfect right out of the gate. There is nothing perfect, and as companies test those systems, more changes are going to occur. So you're in this for the next 12 to 18 months before we really have a grip on this. I truly believe that it's going to be the end of 2025 or the beginning of 2026 before we really get a grasp of what's going on. What I would suggest for you and your company and your team, whoever is involved, is to make sure that you use this motto: do it, measure it, and refine it. When something's wrong, fix it. Don't be afraid to change it just because you don't want to make yet another change. We are going to have to be comfortable with changes, okay? So the next thing we need you to do, compliments of NAR, and this is a request from NAR. This is to appease the Department of Justice, by the way, with their investigation into NAR. Remove the word commission from your vocabulary. Folks, we get paid compensation for doing a job. We are a service industry. We provide a service, and in order to provide that service, we have to get paid our compensation. The commission is impliable that it has to be a percentage, and it never has had to be a percentage. And in many cases going forward, it may not be a percentage. You may see a lot of real estate agents offering a flat fee buyer's agent compensation with the seller and the listing agent agreeing upon those. So we have to keep that in mind also. The next thing I want to talk about is a very important real estate commission rule, folks, and it's Rule 112B. 112B, and it basically says that their offers to purchase cannot include any provision for payment of compensation, okay? Hold on, Marcella, don't get ahead of me. We're going to talk about attorneys with the compensation on the closing statement. We're going to talk about that later. That's going to be towards the end, so stick with me, but we're going there. So you are not allowed at any point on Form 2T as a realtor to put any reference to commission, compensation, etc. It cannot be included. Form 220 cannot be made an addendum to the contract. And the reason is simply because the Real Estate Commission and the Bar Association have said the agents are not a party to the contract. They are not principals. They are merely tools to get to the end. I will tell you, there's a lot of real estate agents out there that are tools. We'll leave those jokes to themselves. But we are a tool to get to the closing. All right. So we are not mentioned on the offer to purchase and contract anywhere except to let us know who the representation is on the very end of it. I believe it's page 13 or 14, if I remember correctly, where the agents' names are. So I like that one, Donald. Nice play, O'Meara. That's a good one. So the other thing you have to remember is that if you communicate compensation on Form 2T, you can be disciplined by the North Carolina Real Estate Commission. I want to make that very clear. You can be disciplined for doing that, so please don't. Again, the Bar Association agrees with the commission 100% on this, that the agent should not be involved. As a result, ladies and gentlemen, listen to me very clearly when I say this. There is no anticipated rule change from the Real Estate Commission allowing compensation to be mentioned in any offer to purchase and contract. The only time that can be done is if you want to take a page out of commercial real estate where they write a letter of intent, they agree on the letter of intent, then they actually have an attorney draw up the contract. If you would like to pay an attorney $10,000 to $15,000 to walk you through the transaction and write your contract, you are certainly able to do so. But you as the licensee should never put that into Form 2T. And because this is a realtor issue, that's where our concentration is going to be. In addition to that, we need to talk about the difference between compensation and concessions. It has always been legal for buyer's agents to write in concessions where the seller would pay some of the buyer's closing costs. Now, for those of you that haven't been licensed for more than a few years, we used to have listings that would say seller to pay $3,000 in closing costs with an acceptable offer. Now, that's the key. As long as you put in their acceptable offer, you can do that. Here's what you cannot do, and let's be very clear on this. What you cannot do is say seller is offering $15,000 in closing costs to cover buyer's agent compensation. We have never, let me say this again, we have never been allowed to be specific as to what the compensation could be used for. That's part of the reason we're not supposed to put $2,500 for a decorating allowance. We're not supposed to put seller to pay $10,000 for a 2-1 buy down. You are not a mortgage lender. If you write 2-1 buy down in your remarks, you now have written a trigger term, which means you've got to go through the RESPA, the truth in lending, all of that, and you don't have the authority to write that because you're only a licensee. Make sense? So be very vague and general. $3,000 in closing costs with an acceptable offer, $15,000 in closing costs with an acceptable offer. By the way, the one piece of math that every Travis and I have been teaching real estate, and Kim Stotesbury's in here. She's been teaching pre-license and post-license for years. And agents have a hard time with the math. But let me tell you what agents can figure out. They can figure out 2%, 2.4%, 2.5%, and 3% of a sale price in their head like that. So if your listing is $500,000 and you're offering $15,000 in concession, we know what you're doing, and it's perfectly legal as long as you don't state anywhere that it can be applied to the buyer's agent compensation. So I hope that's very clear. Now, the other thing that you have to remember with concessions is you need to communicate with your lender. And this is a new piece for buyer's agents that you're going to need to be aware of. Please remember that per the North Carolina Real Estate Commission and per the last 5 years of continuing education in the general update and the BIC-UP class, we've been telling you that there are material facts that apply to every transaction, and the ability of the buyer to complete the transaction is a material fact. Well, if the seller is not paying the buyer's agent compensation and the buyer now has to pay it and they can't afford to buy the house as a result, that's a material fact. So you're going to need 2 pre-qualification or pre-approval letters for your buyers in most cases. You're going to need one that says if the seller pays the compensation, then the buyer qualifies for this. And then you're going to need another one that says if the buyer has to pay their own buyer's agent compensation, they will qualify for this. You could theoretically have 2 pre-qualification and pre-approval letters for every buyer that you're working with. It is imperative that a buyer's agent communicate with the lender for the buyer whom they represent. It is imperative because there may be some situations where the lender says these buyers do not have the cash to close if they have to pay any of the buyer's agent compensation out of pocket. Therefore, the searches need to be limited to those sellers and firms that are willing to pay the buyer's agent compensation. That is perfectly legal, by the way, because the lender has told you this is a material fact that we cannot qualify them if they pay it on their own. So it is a legal directive from the lender that you can follow. Now, in terms of concessions, also, you have to remember there are thousands of different loan programs, folks. The loan that you're getting from your loan officer is being funded by a myriad of possibilities. So there are going to be some scenarios where the concessions are allowed up to 10%. There are going to be other scenarios where concessions are only allowable for up to a fixed amount or a fixed percentage. So you need to communicate with the lender on that. It's more important than ever that the lender and the buyer's agent have an open line of communication. And God help you if you're using one of these online lenders that does not communicate well, because I think that that's going to be a little bit more of a challenge. And I'm not mentioning any names specifically, but you know who I'm talking about. So again, the concessions are a big key. So let's talk about where you cannot disclose compensation. And I've seen all kinds of stuff with people trying to get around this. You cannot use MLS at all or IDX to communicate compensation. If you have your own website where all of the listings on your local MLS come to your website, you cannot transfer across the compensation field is gone from the Triangle MLS and from the Canopy MLS. And by the way, it's got to be gone from every MLS that's realtor owned nationally by Saturday. Saturday is the last day that any MLS will still have the compensation fields available, so it will no longer come across to your IDX. Now, I have seen some larger teams that have said, well, we're just going to have our webmaster go in and add a field at the bottom of each of them so that it says we're paying 2% on this one, 2.5 on that one, 3% on this one, whatever that may be. You're going to have new construction companies, Adams Homes, for example, where Travis Ennis works, who's a good friend of mine. He says that they're just offering a blanket compensation on their website because they're a builder. So they know they are the seller, they are the builder, they are the agent, so they can promote that on their own website, but they cannot promote it to the entirety through MLS. So the second thing we're seeing is that people are talking about putting it in the public or agent-only remarks. Emphasizing that there are 3 bedrooms and 0 baths on the first floor, trying to say 3.0%. Folks, I would be really, and Travis has mentioned it in here, be very careful about circumventing these rules. You're going to see a lot of people that are getting in trouble. And the reason that we're doing this, by the way, is because you can be fined and it can cost you your membership to the MLS. So let me give you a couple of examples of where people are talking about doing this. One is the document manager. For those of you that have a document manager in your MLS where you upload, for example, here in North Carolina, we upload the RPODs, the Residential Property Owners and Association Disclosure Statement. We have the MOG, the MOG, not the OMG, the MOG, the Mineral Oil and Gas Rights. Some agents will upload utility information and things like that. You cannot upload anything that has to do with compensation into that because it would be using MLS to communicate that information. Therefore, it is not allowed. Now, the other thing that people have said, well, I'll just attach a Form 220 to showing time, and every time somebody makes an appointment, they'll automatically get that email. No, you will not, because that's illegal under the terms of the settlement, and it is specifically referenced in the settlement that is being presented for the final approval to the Department of Justice and for the class action suit. So you cannot use showing time to do that either. Now, we've told you now for a few minutes of what you can't do. We're gonna be positive in a minute, and we're gonna tell you what you can do. So we're gonna give you some examples. But I want to emphasize again how important it is for you to follow these rules. This is the notice that was sent out to members of the Topsail Beach Association of Realtors 2 weeks ago, where the first offense is a $1,000 fine. The second offense is a $1,000 fine to the agent and a $1,000 fine to the broker in charge. So if you are a broker in charge and one of your agents does this, you can be fined also. And in this particular group, you'll notice they also have that in that second offense, the agent will receive a 12-month suspension of MLS services. Folks, if you get suspended from the MLS for 12 months, you're out of business because you don't have a way to market your listings unless you're doing it privately through Zillow here, okay? Again, just to be clear, you can manually add on your websites the buyer's agent compensation. So you have to remember that. So be careful with it. I see Mark said a Zoom call he attended had to be 2 clicks away, have your listings on the site, but then you have to click again, and that could contain compensation information. That is exactly one way that you can do it, and we're gonna get into that a little bit more here. So I'm one of those people, folks, that I believe the best way to teach you is to show you how I do it. So I've put this QR code on the screen here. Pull out your phone. I'm going to say something instructors never say during class. Kim Stotesbury would never say, everybody pull out your phone, okay, and take a picture of this QR code. It's going to take you to one of my listings at 1292 Pocomoke Road. Now, for you instructors in here, if you want to use this as an example, I have permission from this seller to be able to share it because basically we're advertising an active listing. But you will notice that in here you have the compensation agreement, which is Form 220. You have the certificate of occupancy. You have the septic permit. You have all of the stuff that would normally go into the document manager on this page. And part of the reason, folks, I'm doing this is we're going to talk in a few minutes about what happens because you're going to see a large number of unrepresented buyers calling you as the listing agent, okay? So you need to be prepared for that. You need to have all of this information so you can make your mandatory disclosures to everyone. Doing it through MLS is not going to be enough because it's only going to cover about 70% of the potential buyers. So here's what I do. Whenever I get an email or a text that I have received a showing request, I go into my notes on my phone. I have the email already typed out with this link. Thank you so much for making an appointment to show my listing at 1292 Pocomoke Road in Franklinton, North Carolina. This link, and I post the link, will take you to all of the information that you need, including the buyer's agent compensation, which is being paid at a rate of 2.4%. That's just the example on this particular listing. If you have any further questions, please feel free to contact me. I just want to make sure that you have all the information necessary. Boom, I send it. Folks, it takes less than 30 seconds for me to do this. And there are a lot of listing agents out there going, oh, it's going to take so much time. I'm going to have so much more work. Folks, let's not BS ourselves. The average real estate agent actually works for about 3.5 hours a day. The rest of it, you're driving to and from appointments and you're listening to crappy music on the radio, which means you're not actually working. So don't tell me you're working 30, 40, 50 hours a day when it's not really happening, okay? So Heather, we're going to get to that a little bit later, so stick with me. But the key here is just to show you an example of how to do that, and we will make sure that it gets done. All right. Now, next piece. Is it possible for the buyer agent and the listing agent to talk on the phone? Yes, if. This is a very big if. All right. You ready? Everybody paying attention? Everybody listen.
Okay.
Listing agents, in order for this to happen, you have to answer your phone. Okay? You have to answer your phone. Buyer's agents, when the listing agent calls back, you have to answer your phone. Okay? There's nothing wrong with having a phone conversation like we always have. If Shauna Voorhees has a listing and I call Shauna, hey, Shauna, it's Brian Pate. How you doing, girl? Hey, Brian, doing great. Business so good, making millions. You know, life is perfect. Everybody's happy, blah, blah, blah. And I say, hey, how much is the buyer compensation on that listing at 123 Happy Hollow Lane? She says, well, it's 2.7%. Okay, great. Thanks so much. I appreciate it. Can you send me something with that in writing? Oh, yeah, I got a form, blah, blah, blah. Folks, that's happened for years. That's happened for years. Peter, stop calling me. Peter Kima trying to call me and disturb me. So the other thing you can do, you can email between each other. You can text between each other. But there's a point of contention here, folks. If you're if you're the listing agent negotiating with the buyer agent, or you're the buyer agent negotiating with the listing agent, and you're going back and forth in writing, whatever you agree upon creates a contractual obligation under North Carolina contract law. So as a listing agent, you can't type, I can't text Victoria Lopez and say, I'm paying 2.4% on this, and she brings me an offer that's $30,000 below list price, and I say, well, we'll accept it, but we're only paying 2% now. You Can't do that. You've already made a contractual agreement with Victoria because you sent that text. Here's the bottom line, folks. In my best Stone Cold Steve Austin, compensation should be discussed before you show the property. It should actually be discussed before you make an appointment. But at a worst case, you should not walk in the front door if you don't know what you're going to get paid. Raise your hand if you'd like to work for free. I rest my case, because if you walk in the door without a compensation agreement with the listing agent, that's exactly what's happening. Now we're seeing all kinds of creative stuff come about here. As I told you, innovation, folks. We're seeing agents that are doing this. They're putting the percentage on the key in the lockbox. Okay, that's great. Is this considered a written agreement? Well, legally in contract law, I could take a picture of the lockbox as I'm opening it, take a picture of this, and I could potentially have a contractual agreement. But it doesn't say 3% of what or 3% to, it just says 3%. And by the way, I don't see this until I'm actually at the property showing it. Okay, so this is where the challenge is, you guys. You got to have that disclosure. Sam, that's a long question. I'm going to get into it here as we get to the end, so stick with me. The other thing you need to be aware of, folks, is you need to be ready for unrepresented buyers. You need to get in front of this. And that's part of the reason I'm recommending that you have an external link through either Google Drive or Dropbox or something like that, like I shared with you earlier. Provide the same info that you've provided in the document manager for years. The big thing is, yes, you'll have to send it to each buyer's agent, but if you get a lead call from your sign and there's a buyer that wants to see your property, not only do you need to send them this, but you would also need to do the working with real estate agents disclosure conversation with them before you walk in the house, and then you would need to get Form 201 or 203 signed also, but that's going to depend on who you're representing in the transaction and how that is going to work. Now, what some agents have talked about doing is creating a sign writer with a QR code for every listing. So anybody that goes up, it says, click on the QR code for all information on this property. There's good, bad, and ugly with that, because if you have a pre-filled out Form 220 where you agree to pay any buyer's agent, if this particular buyer has signed a non-exclusive buyer agency agreement with two agents, and the two agents both find out they go under contract, both of those agents could be submitting Form 220 in order to be paid. So you do have to be careful with this, where you're putting this out. I do not recommend putting your Form 220 on every listing available on your website. It should only go to people that are making appointments for your listing. Okay, so that's just a recommendation. Now on this form, let's talk about 220 here, because people are making Form 220 a lot more complicated than it needs to be. Folks, this form's been around for over 20 years. This is not a new form. It's been here for a while. It's just an aspect of how it's changed just a bit in terms of how we're going to use it. So if you're noticing here on the actual form, Paragraph 1 dictates who's paying the fee. Is it the seller or the listing firm? Remember, folks, let's go back to your basics of agency law, where my pre-licensing instructors here. You want to make sure that you understand the basics of agency. The listing is with the firm, not the individual. The listing is with the firm, not the individual. Kim Stotesbury's nodding with an amen from the pew. I appreciate that. It's with the firm. So if the listing firm's paying it, in this case, I'm going about things the way I've always done it, folks. The seller's going to pay me as the listing firm. I, as the listing firm, am going to pay the buyer's agent compensation to them at the closing table. To me, that's the easiest way to do it. Anybody else remember the old Staples commercial where they hit the easy button and said, wow, that was easy? You need to figure out how to make this easy. If you as a listing agent get this pompous and arrogant notion that everybody should adapt to the way you're going to do it, you're going to be a miserable person to work with, and you're going to piss people off, and they're not going to show your listings. That can be a challenge. So you got to make it as easy as possible. So below this, in the blank below, folks, so Misty says, what reason would you check the seller? Let's suppose, Misty, that I go into a listing presentation, say, Mr. and Mrs. Seller, my fee is 4%. and I normally recommend that the seller pays the buyer's agent compensation. We typically put that into my commission and roll it all together. If you would like to do that differently, we certainly can. Well, the seller, of course, well, I used to be a realtor back in New York, and I'm going to pay the buyer's agent directly. Okay, great. So they're going to be paying that on the closing disclosure, and we're going to have to communicate that with the closing attorney. So it's no different than it's always been. Again, and the EXP agents, this is where EXP agents are only allowed to check seller right now. So EXP is only charging the list side, whether it's 2, 3, 3.5, 2.5, whatever that listing fee that they're charging is, then the seller is going to agree to pay any buyer's agent compensation. The problem is if you don't negotiate with the seller up front as to what they're going to be willing to pay, now you've added an extra layer of negotiation into every single offer to purchase. And if you're in a multiple offer situation and one person's a pain in the ass and one person's not, guess who's going to win the negotiation, even if it's not the most money sometimes? Again, it's all about making it as easy as possible. Also on this form in paragraph 3, you guys, where it talks about term, effectiveness, and expiration. If a buyer's, so there are some agents that are saying, well, I'm going to leave this blank. And then you'll notice in the one I sent to you guys, I've left this blank. My goal is for the buyer's agent to fill this in and write, 15 days after closing date or 30 days after closing date. If the contract is terminated, then this form is invalid. It's null and void. If there's no closing, there's no compensation to be paid. All right. And there's been a lot of conversation. Travis and I had an ad nauseum conversation about this for about 45 minutes one night, is when is the compensation earned? And so that's why it's so important. The position of the Bar Association and the North Carolina Realtors is that if the contract is terminated, there is no fee due. So I think Heather had asked that question earlier. So Heather, what I would do is if you were making an offer that the closing date was September 20th, I would put October 20th as the date that would be the last possible due date. Now, whether we're going to see some people move that up, we're going to see people move that back. Again, innovation, we're going to see people trying different things. The other question that I've gotten is, Brian, who needs to sign this form? Well, for the best benefit of everybody, you would always get everyone to sign this form. Now, you do have to be careful with it. Again, if you put it out there on public websites and you let anybody in the world download this, they could claim that they represented a potential buyer on your property and you'd be obligated to pay them. And it could be, how many of you have ever found out about a family member that happened to have a real estate license in another state and you didn't find out until you were under contract? It could be a problem with this type of form. So that's why you have to do that. You'll notice here that in this particular transaction, because the seller is not paying it, and I already have a written contract to pay it on behalf of the seller, which is in the listing agreement, by the way, the seller has not signed this. There are a lot of people, well, Brian, that makes it an invalid form. No, it doesn't, because the seller is not a party to this payment. It is me paying the buyer's agent. So you can get it signed by both the seller and the listing agent, but it must be signed by whoever is actually making the payment. On the buyer's side, everybody needs to sign it. Buyer's agent and the buyer's agent, the buyer and the buyer's agent. So let's talk about open houses. And folks, I'm going to go ahead and tell you, some of you are going to freak out when I say this. All right. Open houses are going to be unique. Here's why. If you're hosting an open house for one of your firm's listings, so Peter Kaima is with Real Broker and he's got a team of 4 or 5 people. If one of his buyer agents on his team wants to host an open house for any agent in the state for Real Broker, because they are all under a single firm license in North Carolina, any Real Broker can host any other Real Broker's open house. And when people walk up to the door, there is no form that needs to be signed for them to walk through because the host agent represents the seller. All right. It is the epitome of seller sub-agency. Because another person in my firm has the open house and I am with that firm also, I don't need any new paperwork either to represent the seller or to watch a buyer walk through. Make sense? However, As soon as the buyer crosses the line of first substantial contact, you as the host agent now have two obligations as opposed to one. The first conversation you must have is the working with real estate agents disclosure. And at that point, those people need to be presented with the possibility. Remember, it's an agent for real hosting here. So we've got 450 agents across the state. I now have to have the conversation of seller agency, dual agency, designated agency, and I may even want to present to them the option of them representing themselves as the buyer being unrepresented. It's the same form that we've always talked about, you guys. So not only are you going to need the buyer working with real estate agents disclosure, you're going to need the seller version of the working with real estate agents disclosure, because it's the seller's form in paragraph 4 that says the agent that is working with you does not represent you. Okay, so it's very important that you go back. I know we've been looking at this new working with real estate agents disclosure for about 2 years now, but you need to go back and look at it again. I think it's very important. Now, let's suppose that Peter decided to host an open house for one of my listings. Let's look at the difference here, because this is a major change. Number one, the sub-agency is possible, but Peter and I would now have to have a written agreement that he would be a seller sub-agent. Because remember the basic rules of real estate, you cannot market a home as your listing without having written permission. And if they're operating as a seller sub-agent, they would be doing exactly that. Okay, so the first thing is first, the listing firm must agree. Now I'm going to tell you, if Peter's hosting my listing, I don't want him being a sub-agent because he doesn't know the details of the house that I know. So therefore, if he's not a sub-agent, he now must get an executed working with real estate agents disclosure and either Form 201 or 203 signed by anyone before they walk in the house. In other words, you're no longer going to be standing in the kitchen or the living room for your open houses if you're doing an open house for somebody outside of your firm. You will have to be out front and people will have to sign before they come in. Now, in the infancy, folks, buyers are going to say, well, I'll just go find another agent to show me the property. That's great. They're still going to have to sign a document with somebody. And if they don't, there are going to be consequences for the agent that tours the home with them without getting their paperwork signed. Remember, the MLS and the Board of Realtors is now going to be judge and jury on this when you're looking at it. So the next thing that you have to remember is you can use Form 201. This is the exclusive buyer's agency agreement. By the way, I know many of you who took pre-license classes or post-licensing classes with me for years, you always heard me say, try to get a 6-month agreement if you possibly can. The length of those agreements are going to drop. You're going to end up doing you're going to end up doing maybe one weekend, maybe one day, maybe one property. The form allows for all of those. You do not need to have your attorney create a new showing form. We already have them. The Association of Realtors has already provided them. If the buyer refuses to sign an exclusive agency relationship, then you can move to Form 203. Form 203 is a non-exclusive buyer's agency agreement. Basically, folks, Form 203 does the same thing in writing that oral buyer's agency did when you initially presented the working with real estate agents disclosure. Okay, so you have to remember that you have obligations as an oral buyer's agent. But I want you to focus here on this one thing. Look at the compensation of the firm in paragraph 3A. Paragraph 3A, where it says, this agreement does not obligate the buyer to pay a brokerage fee or assure the payment of a brokerage fee to firm. Buyer acknowledges and understands that the firm expects to receive and will seek a fee for firm services under an offer of compensation from a cooperating seller or listing firm in the amount of blank. The bottom line, ladies and gentlemen, is when you sign this form, you are not guaranteed a payment. Let me say that again. If you agree to sign this form with buyers, you are not guaranteed a payment, because if you go in a listing where the seller is not offering buyer agent compensation, then you will not be getting paid. So please be aware. And by the way, that doesn't mean you don't do anything anymore, because you've already entered into an agency agreement where you've agreed to help the buyers, and you can't just walk away and not do your job. You can't just say, well, you're not paying me, therefore I'm not working. No, you got to be careful with that. Don't enter the agreement if you don't know what you're getting paid. So let's talk about the big part. What happens if the buyer is not willing to sign anything? Then a tour of the home is not possible, and to do so would be a violation of MLS rules. Bottom line, period. They must sign something. Again, this is going to take 6 to 12 months for people to learn. It's going to be the case in all states, by the way. So we'll finally have a scenario when people are moving here from another state. They may be familiar with this already. That would be a massive assist to us in that case. So bottom line, folks, let's talk about signatures here with the buyer's agency agreement. Number one, it is going to be possible for you to now charge a retainer fee. There are many agents across the country that have said, okay, I'm just going to charge a flat fee for buyers of $15,000, and you need to write me a check for $1,000 up front, and I'll collect the remaining 15 at the closing table, or the remaining 14, whether it's going to be from the seller or from you, depending on the transaction. Now, again, it's going to take buyers a while to get used to this, but we are a professional service provider. So if you go to an attorney, they're going to charge you a retainer fee. There are a lot of other businesses that charge retainers fees. So that's not going to be unusual. It's going to become more common. Again, as I talked about earlier with the Form 201, with the exclusive buyer agency agreement, you're going to see shorter agreements. You're going to have to deal with that, especially if you've got a buyer coming in to relocate from outside. You're going to end up having to get those shorter terms. We're only going to sign it for 1 weekend. They may not sign with you for 6 months again. The non-exclusive buyer agencies are going to be more prevalent. I do want you to know that there is an NC Court precedent for the enforcement of the buyer's agency agreement. It's going to have to be up to the firm as to whether they go after somebody for the buyer's agent compensation. I would tell you, if your firm's not going to support you in going after the buyer agent compensation when it's actually been earned, then I think that you may want to go searching for another firm. But I think that there are going to be situations where we end up with this. And I do want to, again, reinforce that we have a 2016 Court of Appeals decision. The case was Blondell versus Ahmed, and it verified the contractual nature of both the listing agreement and the buyer's agency agreement in the transaction. And that's part of the reason you see that reference to the Bar Association, making sure that the authority of those forms are still in place as we move forward to updates. One of the biggest challenges that we will face is if you get to the closing table and your buyer's agent compensation exceeds the amount of cash to close that the buyer has. Let's say the buyer's $5,000 short. Please keep in mind that attorneys only put the compensation to the agents on the closing disclosure as a courtesy. It is not required by law. And if the attorney removes it, you're now going to have to go after the buyer in order to collect your money. And so you're going to have to be careful with that and make sure that you are prepared to do so. But again, this can all be solved by making sure that the buyer has the ability to complete the transaction before you begin showing property. Now, a week ago, I presented down in, or a week and a half ago, I presented down in Fayetteville, and I've added this slide. This slide was initially just the concern of first-time buyers and the challenges that they were going to have to do. But we're finding out that the veteran situation is going to be even more difficult, because not only can the buyer, there's a temporary allowance from the Veterans Administration that will allow the buyer to pay the buyer's agent compensation. However, if somebody is giving them gift money to pay that buyer's agent compensation, then it's not an allowable contribution. There are certain contributions that are allowed for veterans and certain ones that are not. And there are so many possibilities with this. I don't want to get into the weeds on it. I think you should call your lender if you're dealing with a VA buyer. So if you're down at Cherry Point, Seymour Johnson, Fort Liberty, whatever they are, if you're doing any military representation, you need to make sure that you ask these questions. Same challenges for first-time buyers. They may not have the cash to actually complete the closing process, and you need to know that before you begin to show them property. Let's talk about fair housing for a minute. And again, be very, very careful with this, folks. You need to have a systematic approach to using this. You need to spend some time working on your business rather than in your business and come up with a system that you and your team will follow, but everybody needs to be treated the same. If you get into a situation where you have one buyer that's a couple from the Midwest that's moving to Raleigh and you handle them one way, and then you have a same-sex couple that's buying and you treat them differently, you are simply asking for problems. So don't wing it. Stop winging it. It's time to be more prepared in your process and make sure that you're ready to go. Lastly, folks, I want you to be aware of people that are using the settlement to push their agendas. There are a lot of coaches out there that are saying, hey, you need to spend $1,500 a month with me in order for me to walk you through this. No, you don't. You need to partner up with your friends. You need to get into places like this where you can meet with other people, get involved with networking with other agents, and talk about the processes that they're going through. Tech companies. There are a whole bunch of tech companies out there that are trying to get you to pay for their services, where they will import the data from IDX and then you send them an email to let them know how much the payout is, and they're going to do it for you. Folks, you don't need to do that. Just use the Dropbox or the G Drive like we were talking about earlier, and it does the exact same thing. Agents don't want to go visit 3 websites in order to find out what they're getting paid. It's the same problem that we have with agents that put an ad out there with information on a listing, but they don't put the price in there, hoping that you'll click on the link to go to their website. And then when they get to your website, they click on the 3rd link to look at houses, and now they got to give you their email and their phone number and stuff like that. Folks, you better stop doing that, or you're going to quit getting leads very quickly. So make sure that you're looking at that. There are other models of the future that are being proposed that are simply disruptors that are trying to change the industry. There's a lot of people saying that Zillow's trying to work on this in the background to try to have their Premier Agent program be more effective. And of course, the biggest one, folks, is the media. The media is using this to get clicks. Inman News knows that anytime they post a story about the realtor settlement, that at least 500,000 people are going to click on it. So don't be surprised that you see some inflammatory headlines. That is happening constantly, okay? All right, folks. That's the presentation. So now it's me and Travis answering questions. I'm going to take a couple of breaths here. By the way, the QR code on the screen is actually to my link tree. If you want to join the Brian Pate Seminars page on Facebook, that's where I'm posting information constantly. There's also a link to my YouTube channel where I will have I already have some videos up on, it's an actual playlist for the NAR settlement, and then we'll be uploading this video onto that also. So check that out. If there's anything that's in there that would be interesting for you, please let us know. And with that, we're going to open the floor to questions. Travis, I'm going to let you referee this spot and take the first few questions.
Sure. And as people ask questions and add, if you want to raise your hand virtually, or if you want to throw it in the chat, I have a couple that I wrote down that came across the chat as you were doing your presentation. By the way, Brian, thank you for doing that. I think it's a really thorough synopsis of kind of where we are. But a couple of interesting questions that I thought came across that would be good for those that weren't following the chat. Heather asked when she would potentially use Form 203, which is the non-exclusive buyer agency agreement, versus the more traditional exclusive buyer agency agreement. And I think that's a really good question. I think the answer, Heather, is going to depend on the buyer and their overall comfort level with things. Keep in mind that we've always had and still have non-exclusive buyer agency in North Carolina of the verbal variety. Verbal buyer agency is not going away as far as the real estate commission is concerned. We just never really had a need for putting non-exclusive buyer agency into writing. And so we did it verbally. But this settlement kind of threw a monkey wrench into that and requires realtors now to have their buyer agency in writing before showing. And so this form now becomes kind of relevant. I can't even talk relevant this morning. That's what happens when I try to read and talk at the same time. And I think, Heather, to answer to your question is when you would use Form 203, I would only use the non-exclusive one if I had a buyer, quite honestly, that I could not make comfortable with the exclusive version. And to me, my advice would be try to figure out a way to make that buyer comfortable with an exclusive one, even if you had to do the exclusive one for that one day or one weekend of showings or one property. Because remember, you can just put the address of one property and do an exclusive buyer agency agreement for that one property. I think that's the better approach. So for me, the non-exclusive version would be sort of like last refuge, like just if I couldn't get anything else. And so that's that would be the answer to that. Brian, did you see? I know Kim's got her hand up, and I'll call on her. But maybe if Brian, you saw anything you wanted to add about that before I get Kim.
No, I think you've covered it well. Kim, what's your question, darling? Kim, you're muted, sweetheart.
You're muted. Let me ask you to unmute. There we go.
Okay, sorry about that, guys. Thank you so much for having this session today. It's been very informative. Brian, nice job, particularly. And Travis, I love you very much. What I wanted to share as an instructor, as an educator, I'm out here training in my little world with my peeps. But what I keep hearing, you must have a written buyer agency agreement. You must have it or you can't show the property. And that's not true. I can show the property as a subagent of the seller. If I work for the listing firm, I'm already a subagent of the seller. So, that's kind of like in-house taken care of. And if I have to have a written buyer agency agreement to show that buyer that house, I've got to have informed consent for dual agency. I'm not hearing anybody focus on that.
Yeah.
And in my opinion, I think it would be easier just to tell the buyer, you know what? I don't know you very well. You don't know me either. You just want to look at this house. Here's the working with real estate agents brochure, and I'm not working for you. I represent the seller. So be careful what you say. Let's go look at the house. Now, as the transaction proceeds, the buyer may say, okay, what about me? What if I want to look at another house? Can you be my buyer's agent? I mean, you can always add that hat. But showing in-house, dual agency is a really big concern. And I'm just imagining it's going to confuse more buyers and cause listing agents and in-house agents to push buyers away if they don't deal with them quickly. And I'm old school, y'all. I've been around since before dirt. And when I got my license, we all represented seller. There was no buyer agency. And when buyer agency came about and we had to start telling people, I'm not working for you, I represent the other side, all of a sudden we had buyer agency and dual agency. This was in 1992, 1993. And over the years, sub-agency across firm lines went away because of vicarious liability. And it was a good thing because we had buyer agency. Now that we have to have written buyer agency agreements with buyers before we can show the house as a buyer agent, I'm wondering why we don't go back to offering sub-agency across firm lines. I can't, in all my years, tell you of a single lawsuit that I'm aware of where the listing firm and the seller got in trouble because the agent on the other side from a cooperating firm made a mistake or did something wrong. That doesn't mean there aren't any, and it's not a risk. But I think it's a minimal risk.
I agree.
2 cents worth.
No, I think, and I appreciate it was more than 2 cents worth for me because I appreciate that. I think that's going to be part of the evolution that Brian talked about earlier that we're going to see over the next year and a half. I think we're going to see the disappearance of holding an open house for somebody else's office. I really do. I think that's going away. I think we will quickly find that is way too complicated for me to hold an open house at one of Brian's listings and we're in a different office. Now, I think it's totally not going to be a problem if you're holding an open house for your own office, but that practice of doing it for somebody else's office is going to become way too complex with this thing. I agree.
And I will tell you, as an independent sole proprietorship operator, I'm not having other people host my open houses anymore. So if I'm out of town on the weekend that the seller wants the open house, we just simply won't have one.
Yeah.
And there are people out there that are already saying, well, I'll just have the seller host the open house for me. I couldn't think of a worse idea than to have the seller talking to buyers when they're walking in the house. So I do want to address one thing that Kim said. I think there's a very important piece, and I understand where you're coming. However, one important piece is we have to make the buyer aware of what their obligations would be in the purchasing process. And many listing firms are not paying seller sub-agents. And so if the listing firm is not agreed in writing in Form 101 to pay the seller sub-agent, even if Kim and I are with the same company and I'm hosting her open house, if the seller agent's not being paid, which by the way, Kim would have an obligation to tell me, then I would have to get every buyer that walked in to let them know you would be responsible for my compensation. And that's the key with it. We don't necessarily have to have an agency agreement, but you have to have the conversation about if the buyer is paying any compensation. So the working with real estate agents disclosure still pacifies the real estate commission for the concept of first substantial contact. It does not satisfy the settlement requirements that say the compensation discussion must happen up front and both buyers and sellers must be made aware that it's not a requirement that an agent be paid. And that's the danger of the Form 203, and that's why it's out there, is so people don't feel obligated for anything. But if I'm the buyer agent, I'm not showing them a listing that doesn't have the seller paying the compensation. So I think there's just as much protection in those forms for the agent as there are for the buyer. And so, again, you don't have to have an agency agreement signed, but you do have to declare as the licensee who you're representing, which is why the working with real estate agents disclosure is presented. And I do agree with you. I think dual agency is going to be a key, but I think that what you are going to see, and I agree with Travis 100%, the demise of the agents from other companies. You know, I see Scott LaRue in here. He and I are both independents, and we've hosted each other's open houses for years and made sure that our E&O included that allowance. We won't be doing that anymore because there's too much BS to walk through in order to be able to make it a legit open house. But I do think what you will see is the rise of listing firms paying seller sub-agents again, where for many years we've seen 3% to the buyer's agent, 0 to a seller sub-agent. I do agree with Kim on that statement that we will see the rise of that and see it happening more often.
So Brian, one thing I wanted to address, and I've gotten this question a couple of times, and it's a great question, and I want to make sure that people don't have a disconnect on this, because you shared your approach, which was to have a website for your listings, and you have the Form 220, prepared in advance, right? Which I think is a great approach. Some people are nervous about that because of a bulletin that the Real Estate Commission put out that said, Rule 112B doesn't allow for pre-printed sales contracts to address compensation. And that is very true. But I want to be clear with everybody, folks. Form 220 is a compensation agreement that takes place between either the listing office and the buyer agent representatives, or between the seller and the buyer agent representatives. Form 220 is not part of the sales contract. In fact, Brian specifically said, don't dare try to make Form 220 an addendum to the sales contract. Don't reference Form 220 in the sales contract. So that Rule 112B, just to be clear, pertains only to the sales contract. It says that pre-printed, fill in the blank sales contracts in North Carolina cannot address brokerage compensation. So what that means basically is the 2T can't address brokerage compensation. There should be no reference in the 2T that the buyer and the seller are creating between each other about the compensation. It is totally appropriate. And in fact, that is the purpose of Form 220, to address compensation on that pre-printed form. And it's totally appropriate if you want to have that already filled out in advance and signed by the seller or signed by the listing firm or signed by both of them, if that's what you want to do. And that's not violating Rule 112B. And I don't like to speak for the Real Estate Commission, but that's a conversation I've had with them on numerous occasions, and I know Brian has as well. And so we want you to feel totally comfortable that you are 100%. And if you get the complaint, send them to me and say, Travis told me. I am totally fine with that. You can use Form 220 and provide it and not run afoul of the Real Estate Commission's rule, but don't reference Form 220 on your 2T. Don't send Form 220 with the 2T, with your offer, and say, where it gives you that box to check for an attorney written addendum. Don't you dare put 220 as an addendum on that offer. Don't do that, because that would be violating Rule 112. I hope I answered that thoroughly.
Well, I want to agree. I want to agree with Travis 100%. If you get reported to the commission, tell them that he told you. So,
right. Exactly.
All right. Mark Smith, I've seen your hand up, but I want to answer one quick question before I come to you. And Michelle Carver asked this question. We've had a couple of listing agents ask for buyer's agents to send them their showing agreements before they communicate the offer of compensation. We've also heard of this with a couple of builders saying the buyer's agents need to provide us with your buyer's agency agreement. I want to be very clear. Those folks have zero right to see that document. They are not a principal in the transaction. It is an agreement between the buyer and the buyer's agent. So you have no obligation to send a listing agent, an on-site agent, or anyone else a copy of that in order to guarantee that you're being paid. And that's, as my daughter says, period. No other discussion is necessary on that. They have no right to require that in any way, shape, or form. Mark, go ahead with your question. You've been waiting patiently, and I appreciate that.
Right. So just a question of practicality. So yesterday, I showed a house. I got a non-exclusive buyer agency filled out. I already had in my hand the cooperating compensation from the listing firm. So I knew going into it how to fill it out and all of that. The date I put like 10 days after, et cetera, et cetera. Today, she wants to take her son and go see that same property. So here's my question. If I take her, or am I good with not having him fill out one? Or if she says, no, I just want you to show it to him, I just want his opinion, I guess to do that, I've got to have him under an agency of some sort.
Okay, so I've gotten this question over and over again, and actually talked with folks from NC Realtors. Whoever is your principal in the transaction, as long as they are with you, they can bring mom and dad, they can bring a contractor, they can bring a friend to show them the property, as long as you are with them, obviously, and as long as the principal is there. If she wants the son to go over with you, just the two of you, you now need a relationship agreement with him. You would need some kind of documentation, yes.
Yep, thank you.
Thanks, Mark. Good question. All right.
I'm gonna address this, and this is gonna. I apologize in advance.
Oh hell, we're getting him wound up. Here we go, folks.
I speak for the North Carolina Association of Realtors. I would never deign to speak for the North Carolina Association of Realtors. I am not an attorney for the North Carolina Association of Realtors. I am free to have a disagreement with the North Carolina Association of Realtors. In my opinion, the attorneys who work for the North Carolina Association of Realtors are dead wrong that you can make a condition of accepting an offer signing Form 220. I believe that violates Rule 112B. The people I have spoken to at the North Carolina Real Estate Commission, who shall remain nameless and who will release an opinion on this at some point in the future, are furious at the North Carolina Association of Realtors for that opinion. The people at the North Carolina Real Estate Commission who issued your license believe it violates 112B to say to a seller, this offer is contingent on you signing Form 220. Don't do that. If you like your license, don't do that. And trust me, the people at NC Realtors are not going to defend your license when the Real Estate Commission comes calling. Do not say, I'm sending you Form 220 with this offer, and the buyer's offer is conditional or contingent, or the buyer's only making this offer if you sign this Form 2. Don't do that. Do not do that. That is my advice to you. That is not advice from NC Realtors, but that is advice from somebody who would like you to keep your real estate license. Don't do that.
And that's going to be a point of contention over the next 60 days. And I know there's an article being written for the next bulletin that's supposed to come out at the end of this month on that very topic. And I will tell you, I agree 100% with Travis on that.
Yeah.
Allison, I see your hand up. Go ahead. You get the floor.
Sorry, I had to find my mute button. Hi. Okay, so I actually had a very similar question to, I think Scott just had a question, right? Or whoever just had that question. We had a person in my office who recently had a buyer agreement signed. The person showed up for the showing, and after having multiple discussions with this person, it was never mentioned that this person was married. This person is married. They brought their spouse with them. They obviously both will be parties on this transaction. What's the play here? Clearly, we need something signed by both. One, how do we ask that without violating any rules or laws? And two, what do you suggest? Just start carrying around extra copies of exclusive and non-exclusive agency agreements with us?
Yes.
I have them on like ready in zip forms, like the mobile version. And I'm not, preaching for zip forms here, but I have the mobile version on my phone, and I have those just kind of ready that I could send to somebody, very quickly if I needed to. So,
Okay. Yeah.
Yeah.
And one more thing. So we just had a work meeting about this, and this is not something I would feel
By the
comfortable
way,
doing,
just
but they were
so you
saying
know,
you can create, right?
Allison, just so you know, our office just had a meeting about
Yes.
this. Is the most scary thing you can preface a question for as an instructor, because that means usually the person that's willing to speak up is usually the one that's the most wrong.
Right. So, well, I'm concerned with this for my business. In the past, you can meet someone and have a conversation, talk to them about working with real estate agents. A relationship can form quickly, but still within the bounds of what's appropriate for buyer agency or, et cetera. We were just talking about how you can create your own showing agreement. You can write it yourself. It does not have to be attorney drafted. Is that, what are your thoughts on that?
Can you? Yes. Should you?
Should you? No.
Should you?
I'm
yeah, just because you can doesn't necessarily mean you should. That's the old cliche, I think, right?
Right.
I don't necessarily think so. Yeah.
Okay. Thanks.
Right. Thanks, Allison.
Scott, you've been super patient. What's up?
Just for clarity purposes, if for the 220 cannot be referenced in the 2T, I get that. I understand it. What's the best practice that you think? Can the Form 220 be sent separate without being mentioned along with the offer, taking the risk that the seller will only sign the 2T? Or is it better just to send the 220 in advance of any offer, and when you get a response, then make your offer?
Okay, so let me give you a real world scenario from a top agent in the triangle market. She has a team of, I think, about 20 people. One of her buyer's agents presented an offer to a seller that it had Form 2T, all of the documentation, and in addition to it was included Form 220. Seller signed the offer to purchase and contract and did not sign Form 220, and now they're having a battle over how they're going to get paid because they sent Form 220 and intended for it to be signed at the same time. Whatever you intend to happen does not necessarily have to happen. It's the same way that we talk, when we talk about politics, anytime you make your statement of what you think is true in your opinion, you have to remember that half of the people in the United States disagree with you. And so you can't expect people to operate the way you would. So the best practice, and let me emphasize those two words, the best practice is to send Form 220 before, if it's not already being provided by the listing agent. And as a listing agent, I want to provide that to people so that they have it in hand so that I can take the stress and fret out of whether or not they're going to get paid on this one. Again, keep it easy, guys. And I'm certainly not here to tell you that that's the only way to do it. I'm telling you, I've talked with people all over the country. I've heard all kinds of ideas. I've heard of agents superimposing the payout in the background of the photos. Folks, keep it simple. Just keep it simple. There's lots of options in how you do it, but you better know what you're getting paid before you walk in the door. I'm not working for free. Period. Now, I know that I am the grumpy old man in this room today because, like Kim, I was licensed back when everybody represented the seller. And, you know, July 1st, 1995 rocked everybody's world when this whole concept of buyer's agency and the working with real estate agents disclosure came about. We're going back to the way we used to do things, folks. You're going to have to get paperwork signed in person and not just electronically. So you're going to need that box in the trunk of your car or in the back of your SUV, because everybody's got the white Mercedes or the BMW SUV, and you're going to need to carry a box in the back there that's got all of these forms pre-filled out so that all you need is signatures so that you can move as quickly as possible. Welcome to the way we did it 30 years ago. Get with it, deal with it, and remember the fact that everybody, just because you can make a phone call and you can do things online, doesn't mean you have to. When you're face to face with someone, establish trust enough, and if they're not willing to sign the document, you have some selling to do. Not on the house, but on using you. And if you can't figure out how to quantify your value verbally, you're going to be in a world of disarray, and you're going to be left behind in this business.
Yeah. So, Brian, and I want to follow up with that. You take the, I love your perspective and I love mine too, because we take a little bit different approach to this answer. Brian's perspective is make it easy on the showing agent. Here's my perspective. I think the real estate commission tells you pretty much have to do it before showing. And here's why. It's a material fact to that buyer whether or not they're going to have to pay their buyer agent compensation. How many of y'all agree that the buyer needs to know whether it's going to cost them money and how much it's going to cost them if they buy that house, right? So to me, that is a material fact of the showing itself, no different than the roof needs replacement or there's a leak in the crawl space or any other material fact that buyer would need to be aware of. And so how in the world can I expect the buyer's agent to be able to disclose that material fact to their client if I haven't told them what the compensation, if any, is that applies to that showing? Because that may dictate, number one, whether the buyer looks at the property or not at all. Number two, how they formulate their offer. Because remember, if they need the seller to pay that compensation, they may need to know, okay, the seller's not offering compensation. So when I make my offer, I need to ask for X number of dollars in seller paid expenses as part of my offer. I just don't think there's any other reasonable way for the buyer's agent to give all the information to their own client than to have it before they walk in the door. So there's to me the license law responsibility of getting it to the showing agent before they walk in the door. That same answer from a different perspective.
Well, and I want to address this real quick in the chat, and then I'll go to Donald here. Janelle Ward talked about the NC Realtors FAQ, and the Realtors FAQ says, well, just send the offer to purchase without signatures. Why the hell am I wasting time sending an offer that doesn't have signatures, folks, especially in a market? You guys know that if you're in the middle of a multiple offer situation, things move fast. And if the seller doesn't have the ability to sign that form, you're asking for trouble because now you've got to go back and forth and get everybody to sign after you've agreed to the terms. That just slows down the process. And I understand that they're off. Again, just because something's an option doesn't mean it's a good option. No matter what systems you come up with, there are going to be negatives to it. But sending a contractual agreement that doesn't have signatures on it means to me, it's not an offer. It's that simple. You send me an offer that doesn't have a signature from your buyer, I'm going to call you back and say, I need a signed copy of that offer before I present it. That's just Brian's opinion, and that and a couple bucks will get you a cup of coffee at McDonald's. Donald, go ahead. Omira.
Real quick. So, you answered part of one of my questions on that. But I've seen some and talked to some about, compensation depends on what the offer is. What's your guys' stance on that? With how, we can be getting in trouble for that or not getting in trouble? And then the second part of that was a Form 220. I know there's some discretion where EXP is not checking seller, listing firm, they're checking seller. And I know you posted the other day where you, listing firm Brian Pate, was offering this. What's y'all's opinion on either one versus the other, or, you know, the difference? And if it is the listing firm, then you can choose, Brian, out of the 6%, 5%, whatever you're getting, what you're paying. Can that then determine on what the offer is? Or so just advice on that, or ideals.
Right. So for fear of having Travis get on his soapbox for 30 minutes, which we don't have
No
the
more.
time for, I'm going to take this question. See, it's those of you that know Travis are smiling because you know I'm right. So again, the options that people have, there are many that you're going to have to adapt to right now. Yes, EXP has chosen to have the seller pay it. So what is the seller paying? How are you going to communicate that? Right now, my understanding is that I would have to call the EXP agent and say, hey, Melissa, how much are you paying out on your listing over in Tyler Run? You know, unless Melissa has chosen, or unless EXP's got a form that they send to agents when they set up a showing. The bottom line is this: if I want to show your listing and I have an hour to make these appointments and get these approvals, and your listing, because your company has a policy that you're not doing this or that, and it makes it more complicated, I have the right to choose just to eliminate that property from the possible showings. And that's going to be a serious ramification of people that make it more difficult. Is what EXP's approach is wrong? Absolutely not. It's perfectly legal. But what they're having to create is a system that works for 50 states. As Pate Realty Group, I only have to worry about things that I have to deal with in North Carolina in my company. And if I decide to change my policy an hour from now, I have a new policy an hour from now. And that's the advantage of being an independent. So there are pluses and minuses of all of these. Again, they can choose to do it however they want. But the bottom line is this: if I don't know how much I'm going to get paid within about 30 minutes of making that appointment, I'm likely canceling the appointment until you communicate with me. And let's face it, folks, we all know realtors have gotten pitiful about communicating with other agents. And I'm just as guilty as the rest. I've had people that have called me and left me a message, and I'm one of those people, if I listen to the voicemail message and it's not appearing as a new message, I sometimes forget to call back. I have made a conscious effort to look at my voicemail 3 times a day and return phone calls. If I don't hear back from you, I'm eliminating your listing, and it's that simple. Okay. Melissa, I see your hands up. You've been patient. Go ahead.
Mine was kind of along the same lines of Donald, and that was, I've heard several listing agents, and I'm a listing agent myself, but to say that, yes, we are compensating buyers agents with an acceptable offer. So like you said, then it's not like they're going to send the 220 form. And so like you just said, if you don't have and know what that, you know, what they are willing to pay, then people are, I mean, buyers agents are just like not going to show that home, where they were saying as a listing agent, that's a negotiating strength, you know, for you're working with your seller and showing your value. And I just don't see it that way, because like you said, buyers agents need to, now that you're saying it, especially, I guess I wasn't aware that it makes sense that compensation is a material fact.
Yep. So let me give you just a quick role play scenario here. Okay. I'm the buyer's agent. I'm calling the listing agent. What is the payout on your listing at 132 Happy Hollow Lane? I'm considering making an appointment for these clients. Well, it'll depend on what the offer is. What does that mean? Well, it's just going to depend on what the offer is. Okay, if I brought you a full price offer, what would be the payout? Well, it depends on the other terms. If you're going to put me through the ringer like that and make me feel like I'm talking to Grant Cardone, I'm hanging up the phone and I'm eliminating the listing as an option. And I'm going to flag your name to make sure that if I pull up your listing again, I don't waste my time with that phone call. Folks, the bottom line is this, and I realize that I'm getting ready to say this, and many of you all still come to my classes. If you're a pain in the ass, people aren't going to work with you. Okay? If you're a pain in the ass, yeah, Kaim, I'm talking to you. If you're a pain in the ass, people are not going to want to work with you. And if you don't make it easy to show your properties, your sellers are going to eventually go, how come we're only getting 3 showings when our neighbor down the street's got 15? And then you're going to have to define that and figure out a way to say, I'm being a pain in the ass to everybody that wants to show it. It's folks, the solution is simple. It's just not easy because everybody's going to have to get to a new process.
And I have a tack on answer to Melissa's question specifically, Melissa. So if I have a buyer who that's super important for, and they need to know the compensation, they need to know if they're going to be paying me, if they can, and if I get the answer of, well, it depends on the offer, I'm going to take that to heart. It depends on the offer. Now, I know I cannot make compensation part of the offer, but I certainly can make seller paid expenses part of the offer. And that's where it goes back to having a good relationship with that buyer's lender. So I'm already going to know, can I ask for enough in seller paid expenses to pay my compensation? So I'm just going to use numbers here. These are example numbers because I think we need to, speak in terms we can all understand. Let's say that that's a $400,000 home and I have a buyer agency agreement that says I'm going to be paid 3%. It's just a number. I'm not saying that's what my buyer agency agreements say. I'm just using a number. Okay. That's $12,000. So if truly the compensation depends on the offer, then our offer is going to come with me suggesting to my buyer, ask the seller to pay $12,000 of your expenses, because that to me is the way to accomplish legally exactly what we're talking about here, which is making the compensation part of the transaction for the buyer so that they're comfortable that it's going to be paid, that they're not going to have to pay it out of pocket. And if that offer is not accepted as written, then, we go back and we renegotiate just like we would any other concession that we've ever done. So that would be my answer.
So my follow-up question, I guess, is...
Hold on 2 seconds, Melissa. I do want to comment because Marianne Mahar's made a good point. EXP is not saying there won't be buyer's agent compensation known. They're saying the seller is paying it, not the company. They're decoupling the commissions. I have no problem with that. How do I know what is being paid? Is there a Form 220 that's going to be signed? How is EXP communicating that? That's what I have not heard from an EXP agent at this point in terms of how they're being paid. I'm just using it as an example that if the seller's paying it and you're not communicating with me what the seller is paying before I make the appointment or before I show the house, I won't show it. It's just, that's my personal opinion. Now, I can't say we're all going to get together and do that. Obviously, that's antitrust in and of itself. But I believe I speak for a lot of agents that say if it's difficult to set the appointment, then it's going to be a process where I just throw out listings that are difficult to work with. Go ahead, Melissa.
So I guess I want to confirm. So you're not saying that I need to necessarily call the listing agent and not only, yes, in writing there or text, they're telling me 2.4 or your Google Drive, that would be lovely. But if I don't get the 220 form, as long as they've told me 2.4% or whatever, and I go show it, because you can't withhold submitting an offer just because you haven't gotten the 220 form back is what I've been told.
I agree.
Agreed. Yeah.
Okay. So then as long as you have it in writing, that is still, so in the case
You said two very important words, in writing. As long as you got it in writing, remember that it's a discussion between a buyer's agent and a listing agent. If you're texting back and forth, you're emailing back and forth, and you agree to a number, you now have a contractual agreement, even if it's not on a formal document.
Okay. So worst case scenario, if the seller or listing agent, whoever, did not give you that 220 form and I have it in a text and we submit an offer and then afterwards the seller does not sign the 220, I'm still getting paid.
I would say that I could legally go after that listing agent, yes, but it may be, you may have to jump through some hoops. Again,
and I'd go right back to my answer, Melissa. To be comfortable with that, my offer would include seller paid expenses, because I would approach it with the buyer of, we don't have this agreement in place yet. You've told me it's important to you that they pay me. This is the one way we can accomplish this with your offer. So if I was in that position and I didn't have Form 220, you can rest assured that I would be, counseling with my buyer that they need to ask for those as seller paid expenses to be 100% sure that they're not going to get stuck and exposed to having to pay our compensation. Because that's, to me, the way you lock it down, where there's no debate.
Okay, thank you.
All right, we've only got time for a couple more because we're over our hour and a half. Sanjeev, you want to go ahead with your question?
Just a quick question. So I remember you talked about this, but I think I missed it. So how to share, what's the best way to share the Form 220 once you get the showing appointment on your listing?
So again, I'm recommending the link that I showed you earlier with the, let me get backwards here.
Yep.
Sorry if I make you guys dizzy.
Yeah, I think Dropbox or
Dropbox, G Drive,
Google Cloud, whatever cloud service you use, just create a folder on there.
Oh, okay. So just put that form over there and send them an email with the link, or a text message with a link.
Yeah, that's what Brian does, and I think that's great. I think that's totally the way to do it.
And is it okay to also send them that form as an attachment to an email?
Sure. Yeah, I think
Okay.
I don't see any problem with doing that, Sanjeev. You can send the only thing I think you have to be worried about with the 220 is coupling it somehow with the offer. I'm just going to give this advice. I think this is going above and beyond. I wouldn't send Form 220 with an offer. I would not, personally, because to me, that gives the air that somehow Form 220 is a part of this offer, a part of this transaction, a part of the agreement between the buyer and the seller. And that's the whole problem that Rule 112 from the Real Estate Commission has. They don't want us to be a third party to the sales transaction between the buyer and the seller. So to me, I'm going to get Form 220, if I'm using it, out of the way before the offer process begins. And if we haven't gotten Form 220 out of the way before the offer process begins, then I'm going to work with my buyer client about making seller paid expenses part of their offer so that we cover it that way. That's my approach. Form 220 before offers, get it locked down. If we can't do that, then I'm going to make it part of seller paid expenses on the offer. But and different people will have different approaches. I'm not saying that's the right approach. I'm just saying that's the way I would handle it, so that I'm not giving the air that somehow 220 is part of the sales contract.
So if I'm I understood this from a listing agent point of view. Now let's say if I'm a buyer agent and the listing agent has not provided me the Form 220, then I should be asking that beforehand before I submit the offer in that case.
You should be asking that before you show the property. That's the whole
Before
point.
I show the property. Okay.
If you don't know how much you're getting paid and by whom when you walk in the door, you've just created massive risk for your business. Period.
Okay, understood. Thank you.
Okay. Michelle Jones, last question. Close us out.
Oh boy. Okay. The fact that this is the last question, people may get a little upset. So I'm so sorry. And I know we covered this, so I'm not trying to beat a dead horse. And Brian, you mentioned this to me in a previous class, but back to this buyer's agency agreement. And we have a lot of people that purchase homes and they're from out of state. And then they have somebody who's representing them. So in all good conscience, if somebody is looking for a house for their friend or whomever, and we say that this person has to have the buyer's agency agreement signed with us, do we see possible more lawsuits in the future because technically that person is not a buyer?
So let me give you a scenario. All right. Mom and dad live here in Durham, and their daughter's going to college at Johns Hopkins. And when she's finishing at the end of December and graduates, she's moving to the Triangle area. So mom and dad want to go looking at houses for their daughter. Make sense?
That's my client. Yes.
Who am I signing the buyers? Who's the buyer?
The daughter.
Okay. So if the parents are not intending to buy the property, wouldn't that be a material fact to a seller before you showed it, knowing that this buyer has no intent of purchasing one? That would create if they went under contract, it would be called an illusory contract. And so I think that you're going to see those being minimized. And I think you need to have the conversation. If she wants to come look at property and she's the one buying it and you're not participating in the transaction in any way, shape, or form, then I need to show her properties. And if you guys want to see, you're going to have to sign a buyer's agency agreement with me in order for me to be able to show the property. And by the way, since I know that I'm going to be a taxi service for you and you're never actually going to buy from me, obviously I'm not saying it this way, but this is the implication. My retainer fee on this is $1,500.
Wow. Okay. What about
okay? So I'm going to make a dad speech here, tied in with a real estate speech. The biggest problem with millennials buying homes right now and Gen Z buying homes right now is that for some reason they're using their own money, but they're giving mom and dad power in the transaction. And whenever dad comes over to look at the house, they're worse than home inspectors. So I would isolate the buyer and say, I'm working with you. You are my client. I am not showing houses to your friend, your mom, your buddy, whoever it is that thinks they're representing you, because that is an absolute waste of my time and theirs. When you get ready to come down for a weekend, let me know. I will set aside all day Saturday and all day Sunday to show you areas. We'll narrow down to which areas you like. We'll find 3 or 4 communities within that area, and we will focus. And when something comes on the market, you're going to have to get back down here quickly, because if it's a good listing and it's priced correctly and in good condition, you got about 36 hours to get an offer in on it. I think we're going to have, folks, we've been in this habit of playing a taxi service to people. And I did it when I was newer. I'm not going to lie to you. His name was Harry Severance. He was the head of trauma surgery at Duke University's emergency room. If anybody remembers the Brady Bill that was written after the Reagan assassination attempt, Harry wrote the law on what the gun does to the brain when the bullet hits. He's exactly the guy you want sewing your nerve endings back together when they've been ripped apart. He is not the guy you want to show houses to. I showed him 87 houses. And when he finally went under contract, we were doing the final walkthrough, and he says, Brian, what happened to the master bedroom curtains? So, well, those weren't part of the contract. He says, well, the only reason I paid $400,000 for this house was because I love those master bedroom curtains. You know, the reaction is to go, well, you're an idiot if you're going to pay $400,000 for curtains. But I let that guy drag me around for 2.5 years, and he got $3,000 worth of curtains out of my final compensation. And it was my fault because I permissioned that behavior. You teach people how to treat you. And if you jump and go whenever anybody says, well, I found a house that I'd like to go look at. Okay, are you in the buying market? No, I just want to go look. Then I'm not your person. We're going to have, folks, you are a professional. You're a professional that provides a service that involves the single largest transaction most people will make in their lives. And most agents don't act like it. And if you feel like I'm scolding you personally, I probably am. But we have to take back control. You know, it's one of those things. I made a post last night on Facebook, and a few people went, oh my God, are you pissed off at me? Did I do something wrong? Well, if you felt like it hit you, maybe you should have been hearing it. So the bottom line is this. We have an obligation to our clients. It's called a fiduciary responsibility. But my number one responsibility is to my creator, my family, and everything that goes around with that, and everything that happens with the client is subsequent to all those other things being in line. And if I'm going to take a Friday evening or a Thursday evening to show you property, or a Saturday afternoon to show you property, you better damn well be qualified to purchase it if I'm going to take away time from my family. So I think Michelle, I don't want you to feel like I'm coming down on you, but if mom and dad want to see houses, fine. They can ride in the car with you and the buyer when that buyer has time to come. I'm not, and you may lose a client over this when you answer it this way. I'm sorry. I don't work with moms and dads. I work with the buyer. Well, we know what she likes. No, you don't. I've found that most parents don't know their children near as well as they think they do in those scenarios. And I've had situations where I took one parent back to the office one day because they were telling me what they were going to do. And when I got back to the office, I said, "You guys have a great day." He says, "What are we doing?" I said, "Well, you keep acting like you're the buyer. You're not the buyer. You have no say-so in what she purchases. She's using her own money. She's got her own qualifications. She's got her own pre-qualification letter. You are here to join us and enjoy the afternoon. You have no input." And he got pissed. And I looked at the daughter. I said, "When you're ready to go looking at houses, just the two of us, let me know." 3 days later, we went looking at houses. She bought it, and he never saw the house until after it closed. You have to control, folks. You run a business. You owe it to yourself to control it. You run it the way you choose to. If you're old enough to remember the movie Fast Times at Ridgemont High, when Spicoli and his buddies walked into the burger shop and he says, "No shirt, no shoes, no dice." That's the way I run my business. You're hiring me as an expert. And if you want to work with me, you're going to work within my parameters. And as Forrest Gump would say, that's all I'm going to say about that. All right, gang. Thank you so much for being here. I hope you've learned something. I know we've got a ton of questions in the chat box, and we could probably be here for hours and hours and hours. I am going to post this to the YouTube channel. So again, let me get to the page with. Oh, I just blew it up. Hold on a second.
Thank you all so much for attending and the great questions. And, I know Brian feels the same way I do. We just want people to figure out how to be successful and stay within the law. And, I am firmly in Brian's camp in the idea that we will not just survive, but I think we'll come out better for it. I honestly do. I really think the other side of this will be better because I think we'll have a better understanding of how to talk about compensation with everybody. But will it be rocky for a while? Sure, it always is. Change is difficult. I mean, those of you that were around when the 2T contract was introduced, holy moly, when that due diligence fee first came into existence, I mean, you'd have thought the world ended overnight. But we figured it out. We got there.
I still have nightmares about alternative 1 and alternative 2.
Oh, I know.
So, gang, thanks so much. Like I said, this is the link to my link tree. I'll be posting everything on the YouTube channel. Hopefully get it on there by the end of the day. I've got a listing appointment in 45 minutes, so it'll be after I get back from that. And yes, I will get Form 220 signed. I'll let you know all about it later. So hope everybody has a great day. As always, we are here to help. I'm out of the country beginning Monday for the next 10 days. So if you got a problem, call Travis. And if you get in trouble for anything that was said in here today, our names are Bill Gallagher. So just report them to the commission and you can let Bill know that we said that because we always do it with a smile. Y'all take a sip of something. Have a great day. Peace.
Thank you.
Bye, everybody.